should have gone to them.
No.
Yes, my lord.
No.
Because
No, not necessary. Not necessary. You see, these were tentative figures. You are right.
yes,
But the figures changed.
I'm coming to
Figures
that.
changed
Lord.
because of the fact that the number of persons assumed cases also underwent a change.
I'm coming to that, my lord.
On verification.
One of the challenges was in what capacity the government suing. The Attorney General made a statement saying we are not going to be pressing for any claims of recovery of what the government is paying. That's in 89. This is 86.
Let me look at the judgment. Let me tell you why it all happened. Look at
So why is that the story?
Let us look at
Why, how,
let us
whose
look at
wisdom,
kindly
whose lack
let
of
us look at
wisdom
the
is not an
context
issue.
and how certain submissions are made. So we are looking at a very extraordinary situation. Sorry to repeat that, because in this extraordinary situation, what could have been anticipated? If the only concern at the review, at the settlement order was if that trial were to go on for long years, unending.
Correct.
That could be avoided and to
So
obviate
people,
that.
therefore, the persons who have suffered should get benefit at an early date. That is the philosophy of a settlement. Correct. Those monies were given have to be disbursed. Now, you made certain statements because to benefit the people who suffered in this. Now you say no, government is spending much more money on different aspects. They are, as tort fees are required to be parceled with those liabilities. Yeah. Claim it. It will be tried. How should in a security be parceled this on to them? Whether it is a claim of relief and rehabilitation, whether it's participation of environment degradation, all these you may not have a claim. We don't know. But you are wanting us to determine these claims in a curative petition dealing with the issue of claim satisfaction of the persons who had suffered various forms of injuries and ailments. How do you mix up all this? How do you do this?
Responsible. It needs to go through the review. I'm not saying these questions are to be discussed like that. But how do we find an answer to this very vexing question? So at different points of time, the courts have looked at certain dimensions of the case. And that's who we gave an answer. And stand was taken by the government of India with other parties. So on the basis of certain assumptions of facts. So therefore with the review.
Those assumptions.
Let me go through the review.
Let us say you find no, those assumptions today don't hold. Get them determined in proper proceedings. Please don't put this in a curative before us. Is all we are saying. If after 39 years you want to now sue them for something, please do it if you can. Please recover it if you can. Actually, claims is like some fresh suit which you are seeking to file. Interested LIBOR rates, CPI to be applied. You are filing a claim today, file a suit then. File a suit for whatever you think is recoverable against them. After 39 years.
Just one more thing. Just turn to your table once again. I don't know. Somebody has to apply. Because here you say, as per the Supreme Court order, the total amount provided is
reading at which page?
page 2. Sorry.
Page 2.
The next
Appendix A.
Appendix A. Column number 2. The total amount provided as per the Supreme Court order was 725 crores.
Yes.
725 crores. Then we turn to the page 3. The total amount paid ex gratia in terms of based upon the Government of India decision dated 24/6/2010, GOMM recommendation dated 27/9/2010 is 740.28. there the gap is very little. It's not substantial, even if you go by your figures. And the figures get really, there's a change in figures largely on account of the fact of the minor injuries. Minor injuries figures going up from,
Astronomically.
it's virtually from 50,000 go to 5,27,000. And that makes a difference of 955, 1,000 crores virtually.
These numbers.
So these are these figures. Then obviously there's something little odd. There is something difficult because the other numbers which have really is 1,000 crores with regard to the government of India expenditure and 315.70 crores on account of environmental damage. Somebody must have done some calculation. These figures will have to be all. How do we
These are only abstract.
So dehoards,
I've given only the abstract.
endeavoring to put in a dehoards the settlement. You feel you are entitled to number of amounts more, which either did not specifically get claimed in the suit or otherwise. Please file whatever you want to before whatever court you want. How can you do it in a curative petition? That's the question.
We'll also kindly turn to some of the observations in the review judgment. And
Tell us where it says
And,
that everything can be opened whenever you want. It is so, we'll see.
Not asking, not what is the definition of minor injury that is defined in an affidavit of October 2006. That whoever was present and filed a claim because of the trauma that they had to suffer because of the gas leak. It's in their affidavit. I'm not exaggerating.
That was defined as a minor injury.
Yes.
these are under the scheme, there are certain.
And the government's words were, whoever was present and filed a claim was granted compensation on account of trauma that had to be gone through. And that the basis of mere presence.
What is the compensation amount, Executive?
I'm sorry.
What is the compensation amount?
50,000.
What's that minor injury?
50,000.
20,000.
Ranges,
And what
there's
then
a range.
becomes, therefore, they say we paid extra 600 crores. Now net present value applying live on.
These are the points.
That's the security.
See, from 50,000 cases of people who may have suffered a trauma, you are, for which 100 crores was provided on 20,000 rupees, you said actually people who have suffered a trauma are 5,27,894.
That's
And therefore we spent 1,000 crores more.
right.
There are
And we had checked for the population of Bhopal at that time was around that thing. 5 million.
56 wards.
So everybody
But
suffered
the
trauma,
purpose
everybody
is
they've given a figure.
There are defined set of wards where the gas leak exposure were determined, and all these people within the 56 wards with a minor injuries category was to be
So
redone.
if you are saying trauma, we are not disputing. So you say that anybody who has been in this affected ward will be effectively treated as somebody who suffered a trauma because the gas leaks occurred there. Therefore, you give it to everybody. Nothing wrong with that. Question is, on this basis, can you open a settlement?
The number is a very important.
Number is because you
Number very
knew
important.
what populations were there. You chose and thought that you will give it to something more. Now, if you want to give it to everybody who has a trauma, salutary benefit.
No, we didn't choose. It's all in terms of the court saying you will go to process this claim under the scheme. The scheme was a well-defined procedure, and it was not an open-ended issue. Therefore, if the scheme allowed people to lodge claims and the commissioners to do their job in terms of the criteria, then unless somebody has to say, yes, all this is wrong.
No, it's not necessary to say it's wrong. Somebody has to say also it is right.
I'll tell you why it is right.
Without evidence, how can
I'll
it be
tell you why
right or wrong?
Therefore, we are only.
You may be right, but how can it be decided?
Therefore,
In a curative, you want us to decide it. We are again and again repeating the same thing. In a curative, what you are saying is, this has been paid by us, ask them to pay this to us. This is what, beyond that, we can't go in curative because we are only dealing with the settlement. There is no trial here, there is no trial there, there is no trial anywhere else.
I quite see that. If the absence of a trial, that's why I said if
Just please
that
see.
trial was.
All the sympathy for all the people who have suffered. Cannot ask us to turn into such an ad hocism
Look at
on determination of amount because you say you are wiser today. That's what is happening.
it is I look at it like it's not a lot simple to say that. And before I do that, can I read both the settlement order and the review judgment, whatever effect they have, bearing on what we are trying to report. So, we'll also kindly pick up volume 1 of the respondent's documents, page 45, that's the first settlement order.
What do you want to read?
I agree. Please turn to page 41, which is the first order in February 14.
Just one clarification for if you turn to your chart at page, sorry, I'm taking you back.
Page number.
It's the figures in just
Appendix A.
appendix A. The amount which was initially provided was 725 crores. Is that correct? As per your chart itself? Then you have additional amount required to be paid. That's an extra amount, which is 675 crores. Is that correct? This is above. This will mean over and above 725 crore. Is that correct? Now, at page number 3, this figure of 740.28 crores under the heading 2, Roman 2, capital 2, ex gratia amount.
Yes.
This amount is the actual amount paid or is the additional amount paid?
Actual amount paid minus,
Not the additional amount paid or the actual amount paid?
minus the initial amount received plus this deducted less amount. The amount was less.
No, so attorney, do you mean that you have paid 675.96 plus 740.28? Have you paid both?
Yes.
Is that your case?
Correct.
No, you have paid, therefore you have paid 675
In excess.
with 675 was paid initially. And thereafter, after 2010, it became 740.28. Or it was in addition to it.
This is in addition to that.
$75.96, the additional amount you paid. They paid 725 and paid 675. Correct? Are we understanding correct? That 725 crores is what was envisaged and provided for. This amount you would have paid, but still somehow 50 crore is lying, which we do not know why it is lying. Then you have paid, according to you, additional amount because of the increase between somewhere increase, somewhere
At the
increase.
actual number of cases, there is an increase. The actual number of cases. The number of cases assumed is 3,000. Actual number of cases 5295. Therefore, an additional amount required to be paid in the last
Without getting into detail, is all arising for whatever it's worth, account of minor injury. There are the figure, there are minor injuries otherwise. So you paid 725 crores you have in your hand to be paid. Correct?
Yes.
Apart from that, you say.
One second. The number of cases assumed in the first column is 2,05,000.
Yes.
When the number of cases went up, which is there in the last but third column, 5,74,000.
Because of this, you are required to pay 725 plus 675.
That's right.
Correct. This is what you say you are required to pay.
And you have paid that amount.
That's right.
And you have paid that amount. Now, please be sure have you paid that amount, because otherwise the question will be posed to you, which we pose. Why is 50 crore lying with the RBI? If you have paid. Who have you not paid? And if you now turn, see, confusion. Now when you come to claim 2, which prima facie is not, they use said amount spent on account of rehabilitation, etc. is so much.
And then amount ex gratia is 740.
Ex gratia is 740. So 1743 is what you have claimed under claim 2. Then there's a claim 3, where you say environment degradation.
You must clearly say whether you have paid 725 plus 675 plus 740.
Out of the 725 which they were supposed to pay initially, they have total paid 740. This is what they want additional.
No. What they must say clearly, whether they have paid 725 plus 675 plus 740. Whether all three figures they have paid.
All the three figures, 740 is a part of the.
So our simple question is whether you have paid one figure of 725.
Plus 740.
No. Let us go by this. So 725 plus 675.96.
675 is required to be paid.
There is addition.
If you lordship gives an
No,
increase in the
additional
number.
But you
By
did not
reason
pay
of
this.
increase in the number,
Let's say increase the number. So 740.
Increase in the
Okay,
number.
let us begin first. You have paid
40.
You have paid 740.
740.
As against 725 is here, we have paid
725 plus 740.
So that means that you have not paid any compensation to those persons who are identified subsequent to the compromise.
Not like that. 670 was required to be paid. Right. But that was on the assumption.
No,
the
but
average
there
amount-
you may not be right, because if you see the simple mathematics, if you see this 675 is in addition to 725. Just calculate it for yourself. Correct.
It because the difference in the number of,
So coming now to the straight question.
yes,
How much is the total amount you have paid on account of all these heads? Death, permanent liability, temporary liability, severe cases, minor injury, loss of property and livestock. How much is the total amount you have paid till today?
725 plus the ex gratia 740 which you made over.
Right.
This has been paid.
Right.
And ex gratia was also given to the ones with minor injuries.
Everyone.
The breakup which you gave, your chart is not complete there. In your chart.
And why is 50 crores lying with the RBI?
The interest amount over a period of time. And
No,
then I
no,
quote
no.
some
I'm not
425
able to.
people
See,
did
you
not.
have paid this amount. This
I
is
will
out-
explain that. That's
This is outflow gone. So you should, all that should have been used in any
the
case.
question. One question is about the amount which has come into our kitty. How have we disbursed it? How the expenditure has taken place? So even if the amount 50 crores lying there, whether it is required to be paid over, in what manner? That's a different question. I am on a fundamentally different issue.
Mr. Tony, there's
If we have paid, suppose we not paid the SGIT at all.
some difficulty. Some difficulty. If you just, Mr. Tony, during the lunchtime, just check up on these figures. There's some difficulty in these figures.
What do you want to explain on the figures?
Just to assist the Lordship.
No, what is the figures? If you have some better definition of the figures.
I'll just come. Now, if your Lordship look at this table, but what happened that initially when the settlement. Right, sir. I'm audible like.
Yes.
Yeah. Milord, initially the settlement came and then there was, Milord, hue and cry that how the settlement has been arrived at. So motto this Hon'ble court took cognizance of the situation. And they said on the basis of assumption that this figure has been arrived at. Now the court was supposed to determine that what is that assumption. So these figures which have been given, if you Lordship look at this table, 3,000 etc. which has been given is based on, my lord, the judgment which was given, which is on 4th of May 1989. I'll just read out, my lord.
Correct.
And what the court said that we have arrived at this figure on the basis of assumption, and if the basic assumption is ultimately disturbed in the sense we find.
No, Mr. Parekh, we are not on that.
No, my lord, I'm just.
We are on the quantum of the amount, not the figures.
No,
of
my lord,
the-
I'm just
on the-
explaining.
under the
I
other
think my explanation will clarify.
Yeah.
So this, my lord, when we look at this number which is given here, assume this number is, my lord, based on what the judgment of this Hon'ble court says. Now, the average amount which has been mentioned, this is the average amount. Again, the court said that in case of death, the average amount will be 2.33. So therefore, my lord, when they multiplied, the total amount came to 725. This is, my lord, for the number which is mentioned here, that is 3,000 sectors, that these are the total amount which has to be given. Now, what happened thereafter, my lord, this 725 was not disbursed immediately because it was subject to, my lord, the determination of claim by the tribunal. So the determination process was going on. So this 725, my lord, the interest accumulated, the interest became, so this amount.
Became larger.
Yes, my lord, it became larger. So suppose the amount was immediately disbursed, for example, in case of death, 233. then my lord, the entire amount of 725 could have been disbursed. Because my lord, the interest became more. Therefore, the question is that interest amount who is entitled to, whether the same number of persons who are mentioned here are entitled to that interest. So this is my lord, a separate thing like 50 crores. Now 50 crores will go to the persons who were really identified by this Hon'ble court on assumption that these are the figures. Now what happened thereafter, my lord? The process of determination started. Now the process of determination by the tribunal came out this particular figure, which is mentioned in column D, that is 5,295, etc. And then for somewhere, my lord, the figure has gone up, somewhere the figure has gone. Like in case of simple injury, it has become tremendous, and lordships are putting the question that how this figure became so much. Now, this is based on the determination which has been done by the tribunal on the basis of, my lord, documents which are produced.
So, what has happened, Mr. Parikh, is if you keep out this category of minor injuries, there is actually excess availability of about 275 crores. I've done the minus and plus only, basic mathematics. It has been so. In the wisdom now, it was decided that while it was envisaged that minor injuries may only be 50,000, effectively minor injuries was categorized as something where there is an element of trauma. One is not saying this is illogical.
30,000
It
something.
is. So practically everybody who was in the area was given that. Therefore, the number of minor injuries cases rose from 50,000 to 5,27,000. There can also be another reason, as the learned attorney said, that a lot of people may have claimed under different heads, maybe under different heads. And via media was that put all these people as having gone through trauma, and therefore they will get some amounts, which is about 20,000 rupees. So give 20,000 to everybody who was in the area. Practically, that is what has happened.
Each claim
While
was
the
determined
claimants
not
under
separate.
different actual heads of permanent disabilities and others, the number of assumptions have been very different or lesser than what actually has been deciphered.
Milord, may I just clarify again from this thing? Now, if we, Milord, stop there, that suppose, Milord, the number was only 3,000, 30,000, etc., then this entire amount of 725 should have gone, Milord, to the persons who have been mentioned in A.
Not
Entire amount
necessary,
should have
no,
gone
no,
to them.
No.
Yes, Milord.
No,
Because
no, not necessary. Not necessary. You see, these were tentative figures, you are right.
yes,
But the figures changed.
I am coming to
Figures
that.
changed
Milord.
because of the fact that the number of persons assumed cases also underwent a
Milord,
change.
I am coming to that, Milord.
On verification, the
I'm
assumed
just coming
cases
to-
were not
Lord,
found
just
to be
give me
so
2
many
minutes.
of the more drastic category, but they fell under persons who were, let us say, had gone through a process of trauma.
Milord,
We are not doubting the government should not try to rehabilitate them.
Milord, I am going, Milord, just kindly give me, Milord, 2 or 3 minutes, I'll clarify. Suppose, Milord, the assumption which is mentioned here, 3,000, 30,000, etc., was correct, and the figures were only that much. Suppose we go, Milord, on that basis. Then it will be that the 725 crores which have been given as part of settlement will be disbursed, Milord, according to the figures which are given in A,
Correct.
including the interest part of it. Am I, Milord, correct to that
Yes,
extent?
yes.
Now we come, Milord, and this is the amount which has been pointed out by this Hon'ble court, which is in C, has to be given in case of death, etc. Now, what has been done is that after determination, this figure has come 5295. We will take on the case of death. So therefore, the difference is 2295. Now, this 2295 has been multiplied with 233, and this figure has been arrived at 53.47. That's how, Milord, the entire whatever was determined by this Hon'ble court has to be given as compensation has been put, Milord, as 675 total. Now, this 675, that is what has been said in curative, is the amount based on whatever this Hon'ble court exercise did in suo moto has to be paid, which is in addition to number which has been given to payable to those who were assumed 3,000, etc.
Only
So this
thing,
figure
only
comes
thing
to
we've understood it. The only
Lordship,
thing I'm
Lord,
telling you
yes.
is that all this variation, somewhere less was being spent, somewhere little more was being spent, but the figure is drastically different because practically everybody who would be in the affected area, a conscious decision was taken to give them at least for minor injuries. Therefore, people who have gone through a trauma would get some amount at
My
least.
lord,
That's the principle.
Not done by government. I want to make it clear. Determination of this trauma has been done by the tribunal.
Maybe by the tribunal. I'm not saying that government will determine it.
And I must make it clear, my lord, the figure which has been given in D, nobody is claiming that the number has increased. Nobody is claiming. The number, because this number has been determined by the tribunal, and the tribunal stopped functioning after a particular point of time. They stopped taking claims. So therefore, my lord, the number which is mentioned here is static. Somewhere, my lord, we have said so, which SLP will be heard later on, that suppose a case of grievous hurt has resulted into death, what will happen in those cases? Because the tribunal is not functioning, who will determine? That question Lordship will decide after the Constitution Bench judgment. Because Lordship said that we will decide this SLP after the judgment by the Constitution Bench of curative petitions. So, but then today we are not concerned with that.
Yes.
Today we are concerned only with the figure, and figure remains static.
Today we are concerned with whether anything more and above in a curative petition can be parceled on to the others.
That
That's
emanates,
all.
my lord, in my humble submission from the order which was given on 4th of May, which will, suo moto, which your lordships may read, because that will throw the light on the
Okay,
entire.
the attorney will read the other, the main two orders after lunch.
Very good. Very good.
I'm grateful. I'm grateful.